She also finds that he has his belief system is still fixed and that his delusions are fixed.
Okay, this is case number 19-10 DC-1583, State of Nevada versus John Kelly O'Connor. Starting with the DA, can you identify yourself and who you represent?
Morning, Your Honor. William Mills, Chief Deputy District Attorney on behalf of the state, accompanied by Chelsea Sanford, Senior Deputy District Attorney.
Good morning. Davies. Good morning, Your Honor. Richard Davies on behalf of Mr. O'Connor. Thank you.
Okay, do we have Mr. O'Connor somewhere?
He is, Your Honor. I can see him on the screen.
I'm here, Your Honor.
Okay, there you are. Okay. Go ahead, Mr. Mills. Present your case. Is the DA there?
Yes, Your Honor. Thank you. And I would just also note that we have Amy Patterson, the evaluator that wrote this report from Lake. She's also on the Zoom call today, Your Honor.
Okay. Go ahead.
And so I don't know what the court's preference is for how we do this, Your Honor. We have there's a couple of things in this report, Your Honor, that's a little bit changed from previous reports. Ms. Patterson continues to find that the defendant is a ongoing danger to himself and others, and that appears to be stable. She also finds that he has his belief system is still fixed and that his delusions are fixed. Which is it's an unshakable conviction that he's right. He still believes that his conduct was justified. His conduct in going in and murdering a man in church, shooting another man in church, and putting the entire congregation at risk was completely justified. And so that is the definition of a danger to himself or others. As you can see from page 8 of Ms. Patterson's report, she states that historically a risk of future violence was often conceptualized in global and stable terms. And I think that this court should actually take that viewpoint and with respect to Mr. O'Connor, that it is his future violence is conceptualized in global and stable terms. He's proven to the court and to everybody else that he is a risk. He killed a person, wounded another person, and put children and other people in harm's way on the day in question. And so that is a global stable term. He is not getting better according to the report. There's nothing different than what he's done from last year to this year where he was into Lakes. There's no improvement. They had him go to some life skills classes. And when he was asked about what he got out of that by Dr. Patterson, he said nothing. He didn't get anything out of it. He is not done anything. He is not going to change. And in fact, according to Dr. Patterson, he's operating at his psychiatric baseline. So this is who he is. He's how he's going to be, and he's never going to get better. And that's assuming that he stays medicated, which, as this court will recall from the proceedings in this matter, he was here once before this court, telling the court, yes, I will stay on my medications. And then he was released from Lakes to the Lyon County Jail, where he did not uphold what he told this court that he would do, and he stopped taking his medications. And that's why we're here. And so there's some assumptions in here. In the reason we're spending a lot of time on this is that Dr. Patterson wants this court to take a new contemporary perspective on risk management, whatever that means. And according to her, the contemporary perspective is the risk of violence is fluid and ever changing. The management of an individual's level of risk is targeted at reducing violence risk. And so to the state, that is not an acceptable thing to happen in this case, Your Honor, because the risk of violence is too great. There's no managing this type of risk. And we'd ask this court to reject that thinking. And also and because the entire last part of the evaluator's report assumes that this court's going to accept that risk management concept of like, we will just put the general public at risk because they don't want to have them put, they are asking this court for permission to explore options to come back to the court at a later date because they're not asking for a conditional release at this time. What they're asking for the court to do is to ask for permission to go look at options to release them into the Reno Sparks or Carson City area and look at those options for that, or maybe Carson City area at a lower level facility. And that they just want to manage the risks at that lower level facility. And they think they can do that. But, you know, they obviously don't have a plan for that. And you can see that in their report, that there's no plan for that, Your Honor. And so, and that they acknowledge that his alleged severe act of violence, which this is not an alleged act, Your Honor. This man went into a church and he murdered somebody. That the monitoring is exceptionally high and that they need to do that. And they said if he doesn't do all these things, that they should have a detailed plan for return to lakes. And they just want to make it more difficult for an individual to engage in violence. The state does not agree with that concept put forward by Ms. Patterson. It is contrary to the interests of the safety of the citizens of Nevada. This defendant, while he may not be actively espousing his belief systems, and he only espouses them when he's asked a direct question, he still believes that what he did was right. And his targets are any number of people. And as this court can see from reviewing all these reports over the years, it's like whoever he's come into contact with. I can remember there was a report, I was the target. Mr. Davies was a target. Mr. Mallory was a target. And he makes a note Dr. Patterson makes a note in this one that this defendant believes that Mr. Mallory is against him. And he has no idea that it has to do with his alleged behavior. And this defendant still does not, to this day, realize the effect that he had outside of what it is on himself. And you can see that from his 2024 evaluation on page 6, where the only thing that he realizes is that he's in a psychiatric facility and he has no idea or has no care for the impact that he had on other people. This is a defendant who is totally unable to conceptualize of anything other than his own needs. And it's a fixed delusional belief. And so, Your Honor, we would ask this court to reject Dr. Patterson's risk assessment, find that he is there's a clear convincing that he is a risk to himself and others, and that he needs to stay at Lakes Crossing, period. Thank you.
Mr. Davies?
Thank you, Judge. Good morning.
I guess the question I should ask are we stipulating to the admission of the report submitted by Patterson,
I
Dr.
am.
Patterson?
Yes, I am.
Mr. Mills?
Yes, Your Honor.
Okay. Because
So,
it was discussed at length. So go ahead, Mr. Davies.
thank you, Judge. And I'm not going to put words in Dr. Patterson's mouth. She's here to speak for herself. The way I read this is the annual report talking about the progress that Mr. O'Connor has made in some areas and needs to make more progress in other areas. I will note in page 3, he's been consistently compliant with prescribed psychotropic medication, denied any thoughts about intentions to harm himself or others, denied any auditory or visual hallucinations. And way I'm reading here is that the division or Lakes could possibly contemplate some type of conditional release in the future if that environment, that scenario was developed through some type of, this is where he would go, this was who would supervise him. So I think we're a little ahead of ourselves in this. I understand that Mr. Mills will certainly make a strong argument against that when the time comes to have that argument. But the way I'm reading on the last page of this is the division would consult with Mr. O'Connor's current treatment team, the prosecuting attorney, Mr. Davies, Mr. O'Connor, and the team would supervise the client in the community, develop a detailed conditional release plan that would be submitted to the court's review. So what we're talking about is a possible conditional release plan there's no plan in place, from what I understand. Dr. Patterson can comment otherwise. That if there is a plan in place, I think Dr. Patterson or somebody from Lakes would present that to this court. We'd have a hearing, probably a very vigorous hearing about whether or not that's makes sense or not. I don't think this is the time to really second guess Dr. Patterson's report about her conclusions. We're not the experts on this, and we don't know exactly what they have in mind. I think the report's very glaringly fair to both sides, and showing the progress that Mr. O'Connor has made and the progress he has not made, and the static aggravating concerns that are permeated throughout this case. And whether or not the division or Lakes and or Dr. Patterson feels like those static concerns can be overcome or dealt with in some type of other environment. We're not there yet. We're not there yet where there's a plan in place for us, for Your Honor, to make that decision, for either one of the attorneys to comment on that. And I understand Mr. Mills's passion about this case. It's disturbing. The underlying facts are very disturbing. I get that. However, that does, here we are years later, and there is a provision in the statute for Mr. O'Connor to have some type of other living environment, and that provision seems to be getting close, maybe met, and that's a time set down the road for a hearing to see if those elements are satisfied to this court. I think it's preponderance of evidence, if I saw that right, that some other environment where he would still be supervised is adequate or not. So my understanding is this report is simply just the annual report. It shows us what's good, what's bad, what hasn't changed, and that there might be an eye in the future towards some other type of living situation for Mr. O'Connor. With that, I'll submit it.
Okay, Dr. Patterson, could you raise your right hand and be sworn? Can the clerk swear her, please?
Yes, Your Honor. Do you solemnly swear or affirm that the testimony that you're about to give in this matter now pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God, or under the pains and penalties of perjury?
I do.
Okay, go ahead. Tell us what's going on, Ms. Patterson.
Sure. Your Honor, thank you. This is an annual report summarizing Mr. O'Connor's progress. As Mr. Mills said, his status has been stable for a number of years at this point. Mr. O'Connor hasn't engaged in any any violence. He hasn't exhibited any instability or impulsivity for the last 7 years. Now, and this is not to say that he is not without risk. He continues to express the delusions that likely led to the alleged offense. And, we understand that his level of risk continues. However, it's my professional opinion that risk could be managed in a setting that is less secure than Lakes Crossing Center. Our knowledge of Mr. O'Connor is extensive at this point. We understand what his baseline is and how best to manage his level of risk. Now, as Mr. Davies said, we do not yet have a plan that would, that we could present to the court. At this point, our social work department is looking for a possible placement in the community. It would have to be a secure placement. They would be given knowledge of Mr. O'Connor's history, and they would have to agree to provide the services that we're asking for, which would be ongoing monitoring, supervision, and participation in treatment. And so we don't have that as yet. And it's
So you're not
possible
proposing that I order that at this time, then?
No,
So this
Your
is
Honor,
something we're looking at in the future.
that's right. And we would like the court's, we would like to understand the court's perspective on whether this is something you would ever entertain. Finding a placement for an individual in the community takes a tremendous amount of work and resources. And, if this is something that the court would never entertain, we would stop right now. However, if the court is willing to hear a conditional release plan were one to be developed, then we would continue with our current plan of trying to find a placement.
Yeah, I don't think I have any choice on that. I mean, that isn't something I say, no, you're never going to get a chance. Mr. Davies, am I correct on that? I mean,
That's what I'm looking at. I'm looking at 178-468, and I think I don't think the court can make a decision, a summary decision ahead of time that I could never consider that. There's a provision for the statute for the court. Yeah. Now it's for a hearing. And I'm browsing this for short notice. I think that there has to be preponderance of evidence, but there's certainly a burden of proof and evidence to be provided and parties to be present. So I agree with you, Your Honor, that there's a provision there that means you have to you exercise your discretion on that.
If I may, Your
Mr.
Honor.
Mills, go ahead.
Thank you. And in that provision that we're talking about, that would be done via petition filed by the division, and which is not the case. And that's why I pointed out, and it's on this page 8 of the report, Your Honor. It's the last full paragraph on there. And as you just heard Dr. Patterson say, it's a lot of work to do into this, and they don't want to do this if they don't think it's a realistic thing that the court may consider. And that goes on to what is the court's view of the risk? That's not a psychological thing, Your Honor. That's all you. That's the judiciary's weighing of those things. And what is the risk? And so you can see that here in the middle of that paragraph, where they talk about historically the risk of future violence was often simplified in global and stable terms, i.e., we know what he's done. He's already accomplished it. He's dangerous. It's stable. He's dangerous. And that's why he needs to be here. And so they framed it, as I read this report from Ms. Patterson, that if you take that historical weighing of risk as the judiciary, then this is not something you go on and do this next part. However, as she goes on to say, if you adopt the contemporary risk of we're just going to risk manage, which is, of course, trying to manage risk. And then, of course, whenever you risk manage, you increase risk for other people in the community. And so as I understand that report, and we met with Dr. Patterson, and she related exactly what she said here, which is like they didn't want to do the work if they didn't think this is something the court was going to do or sign on to this risk analysis strategy. And so, yeah, I'll just leave it at that, Your Honor.
Ms. Patterson or Dr. Patterson? What do you
Yes,
have
Your
to say?
Honor. Well, I would say that, this is a contemporary perspective. I think what Mr. Mills is referring to was a history of just simply identifying level of risk as high, low, maybe moderate. Now the perspective is, what can we do to manage an individual's level of risk in the least restrictive setting possible? And so, it's targeting specific critical factors that we believe to be important, that we believe to be crucial in managing someone. And in this case, those things would be medication compliance. It would be careful monitoring of Mr. O'Connor's mental status to make sure there are no changes. It would also involve, intensive supervision, and everything that goes along with that, including, no access to drugs or alcohol, no access to weapons, 24-hour supervision by staff members, not leaving the facility or placement without staff members. All of those things, however, would be developed, and presented to the court. Those are all what we would consider conditions for the conditional release plan.
And so you're asking me to opine at this point in time whether or not I would ever consider that? Is that what you're saying?
Judge, if I may, and I'm
I
sorry,
don't think I have any choice on that. I think if
Judge, if I
something
may,
yeah, go ahead.
I'm looking at redirecting to 178.468, subsection 1, except as otherwise provided in the section, court must hold a hearing not later than 60 days after. And we have 1B, the division or the person committed to the custody of the administrator files a petition for discharge or conditional release pursuant to our NRS 178.469. So really it's incumbent upon the administrator, Lakes Crossing, to, if they file petitions, incumbent upon this court to hold a hearing within 60 days of that petition. And I agree. So I agree with you, Your Honor. And I think we're just way ahead of our skis at this point. And I understand Dr. Patterson like to have a little bit of a, little direction here. Like they're going to put a lot of heavy lifting in the scene if they can set up an environment for Mr. O'Connor that they feel they could present to this court for a hearing. And I can appreciate not want to put that shoulder to the wheel like that when it's in the court's mind is like, this is never going to happen, doctor. But I think the court's right. The court cannot say that. There's a provision.
I can't say that. So,
and so my suggestion, let's wait. Let's cross that bridge when we get to it. I guess. Unfortunately, that does require a lot of effort by Lakes and Dr. Patterson, and I understand that can be frustrating. But this is also the nature of the business we're in. So.
Yeah, the legislature doesn't always take a lot of things into consideration when they start throwing stuff out there that we have to make decisions on. I'm of the opinion that if you convince me that he can be placed somewhere else and the community will be safe, that I would be under an obligation at that point to go forward with that. But so I'm not foreclosing you trying to achieve that. I think that's what we're trying to.
Yeah,
I think
absolutely.
From the beginning, that's what we're trying to achieve, is some alternative to where he's at now. And it probably doesn't help any that you guys are so overcrowded that at least I had another guy that I committed to your custody. This was last year, and it took 3-4 months for him to get in there. Maybe the legislature will give you, I don't know if they gave you a bunch more money this time or not, but it sounds like we're all, this is just my overarching feeling about mental health in this country. I think we're starting to realize that back when we kicked all those people out of the institutions during, I don't know whose administration it was, that was not very bright. And that we need to come back and fund mental health facilities better. Now, whether or not that'll ever happen, I don't. Did you guys get more money for more facilities this last session?
I'm not entirely sure, Your Honor. I can't speak to that. Those individuals are somewhat above my pay grade. But I will say that finding a placement is likely to be very challenging, and possibly there's the possibility that we won't be able to find an appropriate placement. Services in Northern Nevada, especially outpatient mental health services, are very limited. But we would absolutely do our best to try to find something and then present that to the court.
Yeah, I do specialty courts, and I do one in Reno, and then I do one in Lovelock. And the difference in resources between the two courts that I do the Veterans Court in Reno, and then I do drug DUI out in Lovelock. We got no resources out in Lovelock. And I think we got some grant in the Veterans Court in Reno where we have all kinds of resources. So I think, I don't know. I think the law requires me to consider an alternative placement if you can convince me that everybody will be safe. So, but for this hearing, so no, I would not foreclose that possibility. For this hearing, though, I don't think there isn't any issue here as to him being incompetent without a substantial probability of achieving competency in the foreseeable future. The crime that he committed makes him eligible for placement in custody in a forensic facility. Does anybody disagree with that?
I do not.
And Mr. O'Connor, I hadn't given you a chance to talk. Did you have anything you wanted to say?
No, Your Honor, I'm just listening,
Well,
trying to make sense of everything.
Well, if you do, let me know. Okay, so I'm going to find that he's incompetent without substantial probability of achieving competency in the foreseeable future. That does not foreclose the Lakes Crossing from pursuing some alternative placement. The crime that he was convicted of or is charged with is eligible to be, it makes him eligible to be committed to the placement and custody of a forensic facility. Pursuant to NRS 178-461-3, there's clear and convincing evidence that he has a mental disorder and that the defendant is a danger to himself and others, and that the defendant's dangerousness is such that the defendant requires placement at this time in Lakes Crossing. Anything more that we have today?
No, that's the required finding, Your Honor.
I apologize. I had this down in my calendar for 10 o'clock. And so I was sitting around waiting for it. 10 o'clock. I get so many different emails from so many different places. Being a senior judge, sometimes I'm not sure where I have to be. In any event, does anybody else have anything else? Do you want to prepare an order, Mr. Mills?
We will prepare the order, Your Honor.
Okay, and submit it to me. Anything more,
Your
Dr.
Honor?
Patterson? What? Who's Your Honor in me?
I think that the clerk has a question, Your
I'm
Honor.
sorry, Your Honor. I was just looking to set next year's hearing, if everybody's available. I have a couple of dates.
I'm looking at that right now, Ms. Clerk.
I have the date of August 4th at 1:30 or the date of September 1st at 1:30.
August 4th works for me. August 4th, 1:30. Is that okay for Mr. Mills?
I'm sure it is, Your Honor.
The problem I have is I have on Tuesdays, I have my veterans specialty court and, we staff at 1 and then have court at 2. So the Tuesdays at 1 to 2:30 are the only time I don't have available in August. Could we have another
And
date?
Your Honor,
Or can we do it earlier or later?
that's the only times that I had at this time. I can reach out to the court administrator and then reach out to the parties. And maybe we
So
can move this from
1:30,
August,
how about 3 o'clock on August 4th?
on that August 4th.
Yeah,
Works for
I'll
me.
check, Your Honor, I'll check with her if that's all right with all the parties for
Okay,
3
so-
o'clock.
I'm not available from 1 to 2:30. Actually, 1
That's
to
perfect.
2:45. Okay,
That'll
make it
work.
to
I'll ask the court
2:45.
administrator. Perfect.
okay. So we could set it, why not set it at 9 on that day?
Because that's our Tuesday law in motion, Your Honor.
Okay, so then make it 3 on that day?
I'll check with her. I think that's probably gonna be doable.
Okay. So I'll put it in my calendar right now so that I don't mess it up.
Perfect. And I'll confirm with a setting memo, Your Honor.
Okay. Anything else on this matter then?
Thank you, Judge. Good to see you again.
Have a good day.
Yeah, thank you.
Thank you, Your
Dr.
Honor.
Patterson.